ICSFIT, welcome you to this workshop in intellectual property rights. Today, we gather to explore the intricate realm of copyrights, patents, and infringements with the aim of fostering, understanding, and promoting creativity. With the guidance of our distinguished speaker, Mr. Ajit Kadam, we will learn about keeping our brilliant ideas secure. So, without further ado, let us get started on this fun and informative journey together.
Thank you. Shall we start?
Hey, good morning, everyone. Uh, it's my pleasure to introduce our speaker for today, Mr. Ajit Kadam, an experienced patent and trademark attorney and a partner at More and Kadam Legal Associates. With over 18 years in research and development, Mr. Kadam has a deep understanding of IP protection, particularly in pharmaceuticals, engineering, and automobile. He is proficient at patent drafting, trademark filings, and managing legal proceedings. Mr. Kadam holds a master degree in science and LLB from the University of Mumbai. He is registered to practice before the Intellectual Property Office of India and is also registered with Bar Council of India. So let us welcome Mr. Ajit Kadam as he shares his invaluable insights on intellectual property rights.
Thank you, Vinay. Good morning, all.
Good morning, sir. Good
Good
morning,
morning,
sir.
sir.
Firstly, I want to thank St. Francis Institute for letting me be a part of today's workshop on intellectual property rights. A big thanks to the principal and professors for setting this lecture workshop for all of us. I will assure you that this lecture is not become a boring lecture. Instead, I want us to all to talk and share your ideas also in this session. Your thoughts and questions will make this session more interesting and helpful for everyone. So let's get started and learn together about IPR now. Okay. So to begin with, we will first understand what is meaning of intellectual property rights. So intellectual property right refers to creation of the mind. Okay, such as inventions in bracket new product or new process, literary work, artistic work, design, symbols, any new name, images. Okay, so intellectual property rights are a legal protections granted to the creators or owner of the intellectual property, giving them exclusive right to use, sell, or license their creations for a certain period. Okay, so intellectual property rights, it's the meaning that it is related to the creation of the mind. So new creation is required. Okay, whatever new creations are coming from the mind, so that you can protect it under the intellectual property rights. Okay, in the different forms, like there are several forms are present in the intellectual property rights. So that we will study in the next slide. Okay, IPR is an basically intangible property. So what is the meaning of tangible property and intangible property? So tangible property means tangible properties are physical assets that have a tangible or touchable form. Okay, these are in a physical form, like your real estate, your flat. Okay, then vehicles, equipments, furniture. Okay, cash, coins. These are in the form of physical forms. Okay, so you can touch them. So these are also property. Okay, this is called as a tangible property. And what is meant by intangible property? Intangible properties, on the other hand, lacks a physical form. They don't have any physical form. They are on the paper. Okay. So example here, intellectual property like patent, copyright, trademarks, goodwill of the brand, or shares. When you purchase any shares, this is also intangible property. Okay. So these assets are not physical, making them non-tangible. They often represent ideas, concepts, or legal rights. Intangible properties are valuable but are not typically physical or visible assets. Okay, so this is a basic difference between tangible and intangible property. So IPR is coming under intangible property. So types of IP rights: patent, trademark, design, GI, and copyright. What is the full form of GI? Anybody? Come on. What is the meaning of GI? We must have heard about the turmeric case, basmati, chawal, kolhapuri chappal. What is the full form of GI?
Geographic indication.
Correct. Now we will first see the patent. What is the mean by patent? Okay. So patent is a form of intellectual property right that grants its holder exclusive rights to an invention, preventing others from making, using, selling, or importing the patented invention without permission. The patents are granted by government authorities to encourage innovations and the disclosure of the new inventions to the public. What you understand from this definition? From this definition? It is a intellectual property right. First of all, it is a intellectual property rights. Okay, it gives the exclusive rights to the owner of that patent. Okay, so nobody can use that patented product or patented process without your permission. If you have a patent, then okay. And what rights you are getting? Making. You can make that patented product. You can use that patented product. You can sell that patented product. Okay. Then uh, importing. Okay, so anybody, any third party, if without your permission, if they are doing such type of activities like making, using, selling, importing, so this activity, it will be come under infringement of the patent. Okay, if you are doing without permission of the patent holder. Correct. There are two main types of patents in India. I specifically mentioned in India. Okay, a product patent and process patent. Okay, because in patents there are several other types are also are present, like use patent, method of use patents, method of treatment patents. But these type of patents are not are allowable or not, are they are not allowed in India. But in US and Europe you will get the patents for method of use and method of treatment. But in India you will get the patent for for a product, or you will get the process, that is manufacturing process of the product. Okay, product patent is definition is product patent protects a new and useful product or a significant improvement to an existing product. If you develop any new product, okay, totally new product, then you can go for a product patent. Or product is already there, but you improve that product. Okay, so improved product, it is now in coming going to come in the market. So that improvement, that also you can capture under the product patent. Okay, second is the process patent. A process patent protects a new and useful process or method of manufacturing the product. So product is already known, but the manufacturing methods to manufacture that product, there will be, there may be different number of methods to manufacture a single product. Okay, which is already known. But but that process, if it is new, okay, if it is fulfilling the criteria of getting the patent, then you can file a process patent in India. Okay, so in India there is the two types of patents, like product patent and process patent. Okay, basic idea of granting a patent is what? the applicant applied to the government for the right of patent, and in return for the monopoly must disclose everything about the invention in the patent document. Okay, so basic idea behind the patent is what? Government is giving a rights to you, that is monopoly rights. You can use your patented product or patented process. Nobody can use it without your permission. Okay, but getting a patent, you have to have disclose your whole process or your product to the government. In short, you have to disclose it to the public domain. You cannot hide any steps. You cannot hide any ingredient. Okay, if you want a patent, then you have to disclose all these things to the public. Then only government is ready to give you the patent for around 20 years from the date of filing of the application. Okay, so 20 years you can actually enjoy the monopoly rights for your patented product or your patented process. Correct. But the condition is you have to disclose the all the steps, all the manufacturing details, all the you cannot in short you cannot hide any ingredient or any steps. Okay. So right granted for 20 years from filing date. The product patent no one can use, make, sell, offer for sale or import patented product without patentee's permission. Similarly for process patent also, no one can use the patented process or can do any of the above listed activities for a product obtained through the patented process without patentee's permission. So without patentee's permission, nobody can use, make, sell, offer for sale, or import. Correct. Import means what? Suppose a patent is in India. You have a product or you have a process patent. Okay, and somebody wants to copy of your patent, but he want to manufacture that product in US, and now he is just importing in India. Okay, so that activity will be considered as an infringement of the patent, even though you are not manufacturing in India. Correct. So that's why the import word is there. Who can file a patent? True and first inventor. True and first inventor. Who is the actual inventor? Suppose you invent something and you disclose to your friend, and and that friend is file a patent without informing you. So he will not be called as a true and first inventor. Okay, you have to prove that I am the first inventor. He has just stolen my invention. Okay, so the meaning of true and first inventor means he is the actual inventor. Okay, who is invent that invention. Second, he is slash her assignee in case of patent applicant is a company or a educational institution. Okay, suppose any employee wants to he develop any invention, he is working in a company, so applicant will be company. Okay, but the inventor will be the that employee. He has to assign that invention to the company because he is using the facilities of that company. Okay, so company is funding to that employee to develop that invention. Okay, so in such cases the assignee employee will not become an applicant, the company will be the applicant. Similarly in the educational institution, when you are studying in the any educational institution, you are doing any PhD work in the educational institution, you are using the lab of the educational institution, the educational institution funding you. So in that situation, whatever invention is generated you in your educational career, so that will be the property of educational institution, not of the student. Okay, so that care we have to take. Secondly, his and her legal representative. Suppose any person is dies. So similarly, when we person get die, their legal representative taking care of that all the properties. Similarly, in the patent case also, even IPR cases, the legal representative can carry forward your inventions in the filing process, prosecution process, whatever things are required to protect your intellectual property right. The legal representative can be do it. Okay, alone or jointly with any other person, including a company or educational institution. So any third party, if wants to file a patent, but he want any help from any company or any educational institution, okay, regarding funding and all, but he is not a part of that educational institution. He is not part of the company, but still in collaboration, both can file a patent. Okay, so in that case, both can be applicant. Now we will see the what are the basic criteria for getting a patent. Okay, provided following criteria are fulfilled, you have to for getting a patent. It shall be new. Okay, product slash process. So product, whatever product you are develop or process you are develop, it should be a new, non-obvious to the person's skill in the art. Okay, so that invention should not be the obvious to the person's skill in the art. Person skill in the art means the person who has a average knowledge of that field. Okay, suppose I invented any pharmaceutical drug. Okay, so my invention should not be obvious to the person's skill in the art means what, that person having an average knowledge of that pharmaceutical field. Okay, so your invention should not be obvious to the person's skill in the art, and also it must be technically advanced as compared to the existing product or process. So whatever technology presently available in the public domain, your invention must be technically advanced. Okay, so these are the three main criteria. Okay, must be you have to fulfill, that is new, then non-obvious to the person's skill in the art, third one is technically advanced. Okay, and fourth one is the capable of using or producing in industry. So it should be manufacturable in the industry. Okay, so these criterias you have to fulfill it, then only you will get the patent. Okay, if it is new but not technically advanced, okay, then you will not get the patent. Correct, you have to prove it is new but it is also technically advanced, it is not obvious to the person's skill in the art. So you have to have all the criteria. If it is you fulfill it, then only you will get the patent. Okay, now to understand the concept of novelty, inventive step and non-obviousness, I have included a picture on this slide. Initially people using ink and feather for writing purpose. Okay, then the invention of the pencil came and followed. Later, the ink pen was introduced. Now, let's consider, because all these three are different inventions: ink and feather, pencil, and ink pen. Now, we have to check whether all these three things having a novelty, whether you have an inventive step, non obviousness, okay, and industrially applicable or not. Okay, then only we can say that it is a patentable or not. Okay, now let's consider whether these invention exhibit novelty, inventive step, and non-obviousness. When the pencil was introduced, did it exhibit novelty, inventive step, and non-obviousness as compared to using earlier writing instrument, that is ink and feather? So this is a question to you. Just tell me whether when you are comparing pencil with the ink bottle and feather, whether they're having a novelty. Please give me the answer. Whether it is a new. Hello. As compared to ink and feather, whether writing instrument, that is pencil, that invention is new.
Yes, sir.
So novelty is there.
Yes,
Correct.
yes.
Whether it is obvious to the person skill in the art. No person is the skill in the art here, all are there, because everybody are using writing instrument, that is pencil. Okay, Now, when you are comparing pencil and with ink and feather, whether it is obvious to the person skill in that, yes or no? Hello.
Yes, sir.
Yes, correct. No. So it is not obvious. It is totally different invention.
Yes.
Okay, when we are comparing the earlier one. Okay, whether industrial applicable, it can we manufacture pencil in the industry?
Yes.
Correct. Now you compare with the ink pen with pencil as well as with the ink and feather. So we can call it as prior art for this ink pen because these are the existing knowledge now, pencil and ink feather. Okay. Now you come up with the come up with the new invention that is ink pen. Whether ink pen is having a novelty,
Yes. Yes.
whether it is obvious to the person skill in the art,
Yes.
no, it is not obvious. This totally new invention. Pencil does not have a lid, nib, sorry.
Maybe is not there.
It is totally new. It is not obvious. Obviously, what when we are comparing any suppose any
Okay.
example, they come up with this charger, okay, with white color. If I come up with the black color, it will be obvious. Right?
Yes.
So for getting a patent, you have to have prove the novelty of the invention. It should be non-obvious to the person skill in the art, and it will be manufacturable in the industry. So these three criteria is fulfilling pencil also as well as ink pen when we compare it with the respective prior arts. Now, from this example, you can understand what is novelty in a better manner. Okay. Suppose example one, if Mr. X invented an ink pen for first time in the world. Okay. So you can see the picture of yellow color ink pen. Okay. Then Mr. Y came up with the ink pen with red color for first time. Okay. Does the red color pen has a novelty?
No.
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 Novelty, novelty is there, no?
Mm.
Prior art
Hello.
showing, prior art showing yellow color, and now you come up with the red color. So novelty is there or not?
Yeah. Now it is.
Correct. Does the red color pen has an inventive step? Whether it is no obvious to the person skill in the art, whether it is a technically advanced,
No.
you ask yourself, then you will get the answer.
No, no,
Whether it is a technically advanced as compared to yellow ink pen,
no,
correct?
Mm.
Can a patent be awarded to Mr. Y for a new colored pen?
No.
Correct. So from this example, you can understand now what is the novelty inventive step.
Yes.
Let's see next example. Mr. X invented an ink pen for a first time in the world, produced it in a yellow color. Mr. Y came up with a ballpoint pen with red color for first time. Does the red colored pen has a novelty?
Yes.
Yes.
Yes. Yes.
Okay. Does the red colored pen has an inventive step?
Yes.
Whether it is a technically advanced,
Yes. Technically.
obvious to the person?
Yeah.
yes,
Can a
yes,
patent be awarded to the Mr. Y for a new colored pen?
Yes. Not
Correct?
color, but yeah.
Can a patent can a sorry okay, can a patent be awarded to Mr. Y for a new colored pen? And say, next question is, can a patent be awarded to Mr. Y for a ballpoint pen?
Ballpoint pen you can award, not for a new color. Huh?
Okay, correct. What technically advanced you can prove between these two?
That ink is replaced with some other uh,
At least
ni-
two, three reasons you just try.
nib is different
Okay,
and the ink is different. It's
okay,
solidified form compared to the
okay.
refill.
It is convenient as compared to ink pen,
Yes, the refilling
requiring,
is not.
yes, refilling is not required. Frequent refilling is not
Not right.
required. Correct.
Mm.
So now we will move to the design. Anybody having any question regarding patent, or else we will move to the design?
As you told, it is patented for 20 years only, sir.
Yes, sir. From
One,
date of filing.
okay. So after that, again, we have to reapply.
No, no, no.
Uh, that,
Once the
that
20 years get completed, your invention became free for all the citizens.
okay.
So that in that period, you don't have any third party don't have to take any permission from you.
Okay.
Okay, the monopoly rights only for 20 years.
For any product
Yes, any product or any process.
process in
Yes,
India.
in India.
Other worldwide also same.
Worldwide also same. Yes, 20 years from filing date.
Okay, sir. Thank
Correct.
you. Yes.
So now we will move to design. Design protection in India refers to the legal rights granted to the creators or owners of a novel and original design. Okay, for an article. The protection is provided under the Design Act 2000. The design can be related to the shape, configuration, surface ornamentation, or a combination of these aspects applied to an article. The primary objective of a design protection is to safeguard the aesthetic or visual feature of the product, enhancing its visual appeal and its commercial value. Design protection is relevant for industries where the visual appeal of products is a critical factor, such as fashion, consumer goods, or industrial design. Okay, registering design provides a legal framework to prevent others from copying or imitating the visual feature of a product. When we are saying fashion or industrial designs, fashion means new creations. When we are creating any something new goods with different shapes. Okay, here we are not going to protect that technology. Technical features we are not capturing now. We are capturing only the visual appeal of that product. Okay, so in the fashion industry, the jewelry part, when the jewelers creates new they come up with a new jewelry with new different shapes. So if you want to protect that shapes, you have to file a design application. Okay, how you have made it that product or your jewelry, that design part is not going to protect it. Okay, design only for the shape, outer shape of the product. Okay, this is a bottle. Okay, you can see this is a drinking water. You can see the shape of the bottle. It is a design protected. Okay, if you check in the design website and you check with this company, you can see definitely they have filed a design protection for this bottle shape with the cap design, the bottom of the bottle, the you can see the ribs on the bottles are there. So the way they design that bottle, so that shape we can protect it under the Design Act. Okay, The manufacturing process or that any technical advance if it is there, but that design is not going to taking care of that. Okay, so this is the difference between patent and design. Design only for the outer shape. You can see the pictures. The first is the jewelry, then the tablet shape. You can see the grooves are mentioned on the tablet, so that that shape of the tablet also is design protected. Okay, now the Coca-Cola bottle shape, that also a design protection protected. Now the protection is gone, but just to understand purpose, I just mentioned it on the slide. So the basic use of that grooves, you can break down that tablet at that point where the grooves are there, and different jewelry shapes you can protect it under this design. Okay, the design protection is typically obtained through the process of design registration with the Indian Patent Office. By registering a design, the owner gains exclusive right to use the design for the specified period. Okay. Eligibility. To be eligible for a design protection, design must be new or original and not have been disclosed to the public anywhere in the world before the filing date of the application. So here also similar like patent, it should be new in the world. Okay, it should not be disclosed anywhere in the world. Okay, it should be original work. Additionally, it should be not be a design that is commonly used or published in India before the relevant date. Okay, the duration of protection, the maximum duration of design protection in India is 15 years. Okay, divided into initial period of 10 years, which can be extended for an additional 5 years after this period design enters in the public domain. So in patent you will get a 20 years, in design you will get a 15 years, but that is also divided into two parts. You first you will get a protection for 10 years, and then you can think if it is required, then you can renew for 5 years, maximum for 5 years. So total 10 plus 5 years. So 50 after 15 years, your design shape will be the anybody can use without your permission. Scope of protection. Design protection covers the visual appearance of an article and does not protect the underlying functionality or technical aspects. It is important to distinguish design protection from other form of intellectual property such as patent, which focus on functional and technical innovations. So patent is basically for functionality and technical aspects, technically advanced or not, that criteria is going to check in the patent. But in design, only you will get the protection for outer surface, outer shape of the product. Okay, once the design is registered, the owner has to exclusive right to make, use, and sell article incorporating the registered design. In case of infringement, the owner can take legal action to enforce their rights and seek remedies. Okay, so you have to move to the High Court for any infringement is there, for patent infringement or design infringement. You have to move to your respective high courts. Okay, as per the jurisdiction. This is also a vitamin tablet, a shape of the vitamin tablet. It is also a claim. So that patent number is there, and ornamental design for a vitamin tablet as shown. So tablet, various shapes or various top view, bottom view, side view, perspective views that they are shown in the design patent. Okay. Now we will move to a trademark. Trademark protection in India is governed by Trademark Act 1999, and it provides legal safeguard to the owners of trademarks. A trademark is a distinctive sign that is used to identify and distinguish goods or services of one business from those of others. Okay. Trademarks can include names, logos, symbols, color, shapes, or a combination of these elements. Trademark protection is essential for business to build a brand identity, establish consumer trust, and prevent unauthorized use of their brand elements by others. It helps create a fair and competitive market by ensuring that consumer can rely on the source of the goods or services associated with the particular trademark. Please give me any example of trademark that you are come across day to day life. Some examples, famous examples of trademark.
Fast food logos like McDonald's or Domino's.
Like, you know,
Sir, maybe clothing brands or shoes.
correct.
Logo of cars.
Yes. So these are the brands. Okay, these are the brands. That brands we can protect it under the Trademark Act. Okay, so these brands creates value additions. They creates goodwill. Okay, in the market. So when we are saying this is a Tata product, so you definitely buy that product because you are having faith in that product, in that label. Okay, so that's why the when the Ratan Tata sell the Nano in the market, okay, the Nano is was a totally new invention of the in the car field. Okay, but still public buy that car. Okay, because the label was Tata is was there. People don't know about that time. They don't know about the how the car will work, but they having a faith in the Tata. So that's why they purchase that car. Okay, so this is the value. This is the market value of the trademark. Okay, so it is a very important when you are going into business. You have to create your own trademark. Now the criteria is what if you want to sell any product on a Amazon or in a Flipkart, you must have to protect your whatever label you are using for your selling your product. It should be a trademark protected. Okay, you don't have any you don't have permission to use any other's brand while using any Amazon or Flipkart like platform. Okay, this is a very crucial now. Okay, trademark registration to obtain protection, a person or a business needs to register their trademark with the trademark registry in India. Registration provides the owner with exclusive right to use the trademark in connection with the specified goods or services. There are total 45 classes are there in trademark. So class number 1 to class number 34 is for goods, and class number 35 to class number 45, these are for applicable for services. So depending upon your business and what type of services you are giving, whether you are selling product or whether you are selling just providing services, accordingly you have to decide the class, and in that class you have to protect your mark. Okay, so it is not like in any class you can file your trademark. No, it is depend upon your business activity. Correct. Eligibility: to be eligible for registration, a trademark must be capable of distinguishing the goods or services of one enterprises from those of others. It should be distinctive, non-descriptive, not conflict with existing trademark. Distinctive means it should be different, okay, with one another. Suppose like this is a water bottle, okay. Suppose they are using a Mislery name on the bottle, and already Bisleri is already is in the market. They just now replace the B with M and they come up with Misleri. Okay, so it is called as a it is not distinctive. Okay, it is not distinctive. You are just replaced one alphabet with B with M, so that is not allowed. Okay, even though it is a new, but it will not be allowed by the trademark registry. Okay, non-descriptive. Okay, so when you are selling water bottle, okay, obviously you are selling water. Okay, so your mark should not use any word that are reflecting, we are related to the water. Suppose like jal, okay, like neer. So these are the meanings of water in different languages. So such type of similar type of meaningful words are not allowable in the trademark register when we are when you are filing a trademark. Okay, because this type of words, when they are related to the product, these words are open for the public. You cannot take a monopoly rights on such type of words. Okay, similarly, just for example, apple. Okay, apple means what? When we are writing in a Google apple, you will get the Apple industry products like laptop, like mobile. They're not giving any references like fruit apple. No, Apple is there, name is there, but they're what they're selling laptop and mobile. Okay, so Apple is not related to the product. That is allowable. But any suppose any persons want to sell apples, actual fruit. Okay, and he wants to file a trademark for apple, particularly for a fruit box. Okay, we want that mark on a fruit box. So trademark registry will not allow to give you that protection because it is related to that product. Okay, so apple is then now open for the public when you are selling any fruit, actual fruit. But apple is allowable for a laptop because this is not related to the product. Correct. Not, and third one is the not conflict with the existing trademark. So similarly, like just now I said, that is bisleri and mislary. Okay, so will not allow you. You are now you're taking the benefit of the bisleri, and you are selling your product by taking the goodwill of the bisleri because public purchasing your product considering that bisleri and mislary are coming from the same industry, same company. Okay, and considering that public are purchasing your mislary product, so this is not allowable as per the trademark act. So your mark should be sufficiently distinctive. Just by one two alphabets you replacing by other alphabets, and phonetically it is sound same, but while writing it's giving, suppose instead of I write double e. Okay, and you are saying that my spelling is different, but when you are phonetically sound is same. So such type of trademarks will not be allowable as per trademark act. Okay, duration of protection: once registered, a trademark protected for an initial period of 10 years. Okay, which can be indefinitely renewed in a successive 10-year period as long as the renewal fees are paid. So here there is a no limit as like patent or trademark. Okay, you can use your trademark lifetime. Okay, just you have to renew after every 10 years you have to renew your trademark by paying the specified fee. Okay, so there is no any expiry of there, but if you not paid the renewal fee, your mark get refused. Okay, so that care you have to take. After 10 years you have to renew that, you know for next 10 years. Scope of protection: trademark protection gives the owner the exclusive right to use the registered mark in connection with the specified goods or services. It also allows the owners to take the legal action against others who use a similar or identical marks in a way that may cause confusion among the consumers. Okay, suppose your mark is very similar and is creating confusion in the public domain. Okay, then the actual register owner of the registered mark, he can take a legal action against the who is fraudulently use the your mark, registered mark. You can take action, legal action. You can file a suit against such person in a high court. Enforcement: trademark owners can enforce their rights by taking legal action against infringer. This may include seeking injunctions to stop unauthorized use of the mark, claiming damages for infringement, and other legal remedies. Punishment from 6 months to 3 years with heavy fine. So 6 months to 3 years is a imprisonment. Okay, with heavy fine. So that also is present in trademark case. Well-known trademarks. India recognizes the concept of well-known trademarks, providing extra protection to the mark that are widely known and enjoy high level of reputation. Example: Bisleri, Apple, Godrej, Jio, Reliance, Tata. Okay, these are declared by the trademark registry. These are the marks, are well-known marks. Now any third person cannot file similar or same like trademark in any class 1 to 45. Okay, so that extra protection is given by the trademark registry. So it is called as a well-known trademarks now. Okay, these are some symbols or devices I put on the slide. It is LexisNexis, Vodafone Professional Courier, Air India. So can you tell me which are the trademarks are providing goods and which are the trademarks providing services?
Apple is providing goods.
Okay,
Air India transportation.
okay.
Professional courier is service. Vodafone service.
So Apple is providing goods and rest of others are providing services, correct?
Yes, yes.
Okay. Here,
Coca-Cola product. Crocin also product. Eno is also product. Benadryl is also product.
correct. So these are providing goods.
Yes. Yes.
Now we move to the geographical indication, GI. Geographical indication protection in India is form of intellectual property rights that safeguard the goods of originating from particular geographical origin, correct? Where a given quality, reputation, or characteristic of the product is essentially attributable to its place of origin. The Geographical Indication of Goods Registration and Protection Act 1999 governs the protection of geographical indications. So for each IPR, IP, there is a different acts are present, like Patent Act, Trademark Act, GI Act. Okay, so under that act, you can protect your respective IP innovations. Okay, so example: Puneri Pagdi, Darjeeling tea, Paithani sari, Munga silk, and Patta Chitra. So these are having significance because of the geographical origin. Okay, this is because of that region, specific region. They are giving specific values to these products. Okay, because Puneri Pagdi you can manufacture in anywhere in the world, anywhere in India also. But the the way the Karagir are present in Pune or that region, and they preparing that product, they having a significance because of that particular region. Darjeeling tea also is cultivated in different parts of the India, but Darjeeling tea having a specific taste because of that region. Okay, so that's why it is protected under the GI, protectable under GI. Okay, it's Nagpur orange, Kullu shawl. Okay, Oranges are giving typical test, Nagpur oranges. Then Devgad Alfonso, Swiss chocolates. Okay, so these are, they're giving particular test because of the region, their environment, soil, particularly registered by association of a person or producers or by organization or a authority established under any law representing the interest of the producer. Here you can see GI cannot be filed by any individual person. Okay, it it can be filed by group of farmers. Okay, or any association or any organization. Okay, so GI is not applicable for any individual person. Okay, no person can take monopoly rights just by filing by his own GI application. So that is the restriction over there. Can be renewed after each 10 years like trademark, and infringement is also is there, penalty is 50,000 to 2 lakhs, and imprisonment is also is there, 6 months to 3 years. Okay, so nobody can, use the GI tag on any other product, like any Swiss chocolates is there, and anybody is, manufacturing in any different area and just putting the Swiss chocolate on label on the box, and he's misguiding the people. Then in that case the GI protection will give you the rights to take a action against against such company or organization. Now copyright in India refers to the legal protection granted to the creator of original work of authorship. The protection is governed by the Copyright Act 1957, and it grants exclusive rights to the creator or owners of a certain type of works, allowing them to control the use and reproduction of their creation. Copyright protection is automatic upon the creation of a qualifying works. No formal registration is required for obtaining a copyright in India. When you are creating any something, any drawing or any pictures, on that point of time copyright gets started, your rights get started. But problem is when somebody infringing your rights, trying to infringement your copyright, that time the protection, if you go for copyright protection, that time that certificate will definitely will give you support in the court, in the while litigation part. So copyright is not mandatory to take to file a copyright protection, so copyright application. Once you draw any picture, your copyrights right gets started from that day. Okay, but if any third party started infringement by using your drawing, so it is very difficult to prove in the court. So it is advisable, even though act is saying copyright application is not required to file for your innovative work, but in practicing it says that court practice says that you go for copyright protection, because it is evidence for your innovative work. Okay, so that it is very easy to prove in a court. Okay, to stop others while using your creative work. Okay, the Copyright Act protects a wide range of work including literary work like books, okay, artistic work, musical work, dramatic work, cinematographic work, sound recording, and software. So your innovations, if it is coming under this category, then you have to you will get the protection under Copyright Act. Okay, ownership and duration, the creator of a work is typically the first owner of the copyright. The duration of copyright protection varies depending on the type of work. For example, in the case of literary, dramatic, musical, artistic work, the duration lifetime of the author. You can see once you get the copyright, it will be applicable for lifetime of the author, even plus 60 year after death of that author. You can see this huge protection will get under the Copyright Act. Okay, and in the case of cinematographic film, sound recording, and photographs, the duration is 60 year from the date of publication. Okay, The right conferred, that is, copyright owner has an exclusive right to reproduce the work, distribute copies, perform or display the work, create derivative works. Others may use the work only with the permission of the copyright owner. Like in YouTube, you see the number of videos, but sometimes the songs are, they keep in mute, okay, because they are not taken the permission of the original creator of the that particular song. If you use any song, any movie song in your video in the YouTube, if you are using any, this type of platforms where you are commercial value is there, so in such cases you will get the notice from YouTube, or you will get the notice from the original creator of that particular work. Okay, so it is not allowable to use any of the copyrighted matter without taking permission. When the commercial value is there, when we are using for a commercial activity. Similarly, when we are using any books, most of the time students just making Xerox copy, taking photocopies of the books, but that book is already copyright protected. Okay, legally it is not allowable, but the students are using for their education purpose. They are not using for a commercial purpose. So that's why most of the cases, the owner of the or author of the that book is not taking legal action against any students and all these things, but it is not allowed. But if it is using photocopy of the any books, use copyright is already is there, then the company or the author, he can take the action against any such type of institutions. Okay, because their commercial value is there. So that care we have to take when we are copying anything, or when we are copying any data from Google directly, any images directly from Google, and we are paste it on our uh, you know any board which is displaying outside of the road. So that means there is a commercial values there. Okay, most of the time we have one case that is copyright infringement. In that, what happened? The yoga tuition was there, and they use any typical yoga figures. They copied from the Google and just paste it on their display board, and they publish it on the Facebook. Okay. Now the actual owner, they send a notice to that yoga manager that you are using our figure, that already they are copyrighted. Okay, so we have to take care while copying anything from directly from any Google. Copyright infringement occurs when someone violates the exclusive right of the copyright owner without permission. The copyright owner can take legal action to enforce their rights, seeking remedies such as injunction, damages, and account of profit. Okay, so injunction means what? Injunction means immediately stop. So court can order injunction against the who has infringed that your copyright right. Okay. Secondly, he can ask for damages. Okay, or account of profit. He can ask who has infringed your copyright rights. He can court can ask you to give you the account details. How much your profit you are earn from by copyright by infringing this copyright rights. So based on that, court will decide how much penalty become applicable to that infringer. India is a signatory to international agreement related to the copyright, including the Berne Convention, which provide for the recognition of copyright across member of countries. So when you are article or any book, if your copyright protected in India, that protection will be applicable for whole world. Okay, but in case of patent, in case of design, in case of trademark, it is the territorial rights. When you are applying for a patent, if you are when you are applying for a design, when you are applying for a trademark, that is applicable only for India. Okay, So suppose you want, if you want to protect your patented invention in US, similar invention, so you have to file a patent in US also. Just by filing patent in India, you will not get the patent protection in US. So country wise, you have to take this patent protection, even though it is same invention. Similar for design, similar for trademark. But for copyright, once you file in India, it will be applicable for whole world. Okay. So literary covers imaginative or creative writing. Dramatic work covers a play for performance on the stage or television or in the movie, etc. Musical work, artistic work covers artistic work include graphic work such as painting, drawing, diagrams, photographs, woodcuts, and similar. Cinematographic works includes any motion picture of the story, drama, episode, or event, and computer program. So, if your work, if your invention is coming under this category, you have to protect it under the Copyright Act. So, symbolically, I have shown on the slide drawing, painting, photographs, novel, musical work. Okay, you can see the symbol in circle C is there. That means it is a symbol of copyright protected. Okay, most of the time you can see on the product the label, beside that label, circle with R or circle with TM is there. What is the meaning of that?
It
Have,
is a trademark, no?
have you observed that?
Yes, yes, sir. So TM is a trademark
And R means,
registered. That means
Registered.
Registered trademark.
and TM,
Trademark.
Trademark.
how?
R is only registered. TM is a trademark. Means something is registered that. Uh,
No. So R means registered trademark and TM is trademark applied, but still it is not registered. It is under
okay, okay.
process.
Hmm. Okay.
Okay. So you don't have to wait for till registration of your trademark. You can use that mark immediately, but you have to put that TM. Okay. Beside that your device or beside your logo. That indication is that it is not yet registered, but I have applied for that. Okay. So you are making awareness in the society that don't infringe my trademark. It is under process. Okay. And for copyright, the circle with C is there. You can see in the books they use this symbol.
Yes, yes.
So now, any questions?
Yes, sir.
Hmm.
So, am I audible?
Yes.
Sir, so any project that is uploaded on GitHub, can it be copyrighted?
Pardon?
Sir, any project that is uploaded on GitHub, can it be copyrighted?
If it is new, okay. If it is new and it is published, it is I don't know actually the hub what you have said. That I have to check first. Okay, but it is a, if it is original work and if you are author, then definitely you can go for a copyright protection. If you are feel that that type of work is going to infringe or somebody else can use that work, okay, so definitely you protect it under the Copyright Act.
Sir, I have seen sometimes they are changing the bottle shape, many like Coca-Cola, like big brands, even coconut oil.
Hmm.
What I heard to avoid the duplication.
Yes.
So every time design changes, they are again that is design they are registering.
Yes. Yes. Yes.
Oh,
Yes.
thank you.
So different steps you will find slight differentiation is there because design is not that much stringent like patent. Okay. Just by slight differentiation in your design,
Hmm.
that will give you the design protection.
Yes, yes. Okay.
Okay, but patent is a very stringent criteria, that is novelty, inventive step, non-obviousness. Okay, but in design,
Slight, okay.
stringentness is not that
Not
much.
there. Okay.
Yes, correct.
Okay. Thank you.
Sir, I have a doubt. How can I protect my creative work on social media to prevent plagiarism?
Yes,
How can I protect my creative work on social media to prevent plagiarism?
by filing copyright protection. If it is coming under copyright, then you have to see, when you are saying a patent, your design, the criteria is should be new. What is the meaning of new? It will not be published in a public domain before the date of filing. Okay, so you have to, first of all, you have to understand whether my invention is coming under patent category, whether it is coming under design category, whether it is coming under copyright category. Okay, according to that you have to decide, because patent and design, if you publish it without filing, okay, that means novelty is gone. So most of the time, the educational institution, when PhD students approach us, we guide them कि you file a patent protection, then you publish your invention to the any journal, or to the any learn society. So before that you take precautionary measure, yet you file it. Whether you are going to grant or not, that is the other part, but at least you file it. Whatever you are going to disclose, that you have to first you file it, you save that filing date, and then you disclose to the whoever is there, professors, or in any journal or something. Okay, so similarly, in the when you are saying that you are going to publish your social media, that means you are breaking your novelty. Correct. Once you disclose on the social media, you will not applicable for patent and design act. Okay. Okay. And if it is copyright in, it's okay. You can file it, but you have to prove that you are the original owner. And when you are publish it, that date is also is important. In trademark case, there is not a restriction. You can use it. There is no any such bar like patent and design. Suppose you are using your trademark since last 10 years, and now you are going to file a trademark registration. If you can prove that I am using since last 10 years, then also it is acceptable by the trademark registry. Okay, so these are the different rules for different IPRs. So accordingly, you have to take a decision while publishing your innovation on a social media.
Sir,
Anything else?
So, how can someone with small business protect their intellectual property on a limited budget?
I don't understand your question. Limited budget.
Sorry, sir. Uh, means the small business has a limited budget, but they have their own intellectual property.
Huh.
So, how can someone with small business protect their intellectual property on a limited budget?
Now central government giving the opportunity for small businessmen like startups, okay, small entity, okay. So for that purposes, government already reduced the government fee, okay. So that benefit such type of business can take it, okay, to protect the even patents. Also, the government fee is reduced almost one fourth, okay. So suppose the individual person paying 4,500, then company has to pay around 16,000. Okay. So if it the organization is a startup or small entity, your fee become not a 16,000. It will come under 4,500. So that type of benefits already government given under the design, trademark, as well as under the patent. So the small industry can take the benefits of that of this. The copyright fee already is less, or it is ranging around 500 rupees to 2000 rupees. Okay, only in the cinematographic, I think it is a 5000 rupees. So it's already is less.
Okay, thank you, sir.
Any question?
Sir, as a student, if I come up with some project idea, but as I'm not able to implement it, I come up with a group. So, in what way is IPR distributed among us? Like, since do what kind of patent or copyright do I get?
See, patent is not is granted for any idea. By patent, the criteria for getting a patent, you have to mention in the patent application that you are holding your invented product or invented process. That's why you are going for filing a patent application. Okay, just by saying it is an idea in my mind, okay, so you will not get the patent. So that you have to establish first. Copyright, if it is there, you can any algorithm, if you are design any algorithm or any cinematographic, the draft is there, that you can copyright. So copyright office will not going to check whether you are converted into movie or not. No. Okay, so depend upon the what invention you possessing. So accordingly, the IPR will applicable for you. But design and patent, you must hold the invention. Just by idea, not allowable. Understood? I think I have clear your doubt.
Yes, sir. So I would like to take a moment to thank Ajit Kadam sir for from on behalf of everyone present here from IST SFIT, IIT SFIT. I extend my heartfelt gratitude to you for gracing us with your expertise and also for providing these valuable insight during this enlightening session. Your depth of knowledge and passion in this field has truly enriched our understanding and inspired us to safeguard our creative endeavors. We are immensely grateful for your time, dedication, and wisdom you have shared with us today. So, thank you, Mr. Kadam, for your valuable insight and contribution to this event.
Thank you. Thank you very much. I also uh, happy that you participate by asking the questions. Okay,
Mm.
so it makes a interactive session
Yes,
today.
sir. Many people ask for questions. Generally, online people don't ask. Now, at least we are